2025 is upon us, and with it comes a new wave of constitutional challenges that will shape the future of America. From the shifting tide of democracy and racial controversies to the balance of power between states and the federal government, we are on the brink of critical legal decisions that will forever alter the framework of the U.S. Constitution. Hey everyone, I'm Attractive Nuisance, and welcome to Leisurely Law, where we delve into the most pressing constitutional issues the U.S. is facing. In this series on the U.S. Constitution, I'll break down the law as it currently stands and the policy issues we're likely to face in 2025. Thanks for joining me as we unpack the legal battles, landmark cases, and debates that will define the next era of American law. Get ready to challenge your assumptions because the U.S. Constitution is not always what it seems. Subscribe and hit that bell to stay informed of the latest legal issues, and let's dive into the constitutional debates of tomorrow, today. Today, we're going to talk about the Fourth Amendment in the U.S. As I'm sure many Americans are aware, the Fourth Amendment protects citizens of the U.S. from unreasonable search and seizure. And so that often pertains to police stops, parting, anything from getting pulled over, anything along those lines. Search and seizure might pertain, and citizens have the right to be protected from anything that's unreasonable. And so the police often have to have some basis for their act. More specifically, in the Fourth Amendment range is stop, question, and frisk. And stop, question, frisk is a practice that has been known in the U.S. to result in a lot of violence. It's a very controversial topic. The range of discretion that police officers can be given is highly debated. So that's what we're going to dive into today, is the stop, question, frisk controversy with the Fourth Amendment. So before we get started, I want to first outline what is a right versus what is a privilege, because I know that those are often confused and they're correlated, and some people will use it interchangeably in conversation, but they are very, very distinct things. So privileges are something that can be granted and can also be taken away. You have no entitlement to it. It's not guaranteed. So it's some kind of special benefit. So in Canada, under our both federal law and Canadian provincial regulations, a common privilege that we're aware of is driving. Driving in Canada is not a right, it is a privilege, and that's why we have to go through the whole driver's license situation to essentially earn that privilege or be granted it. And then if we conduct activity that is not in line with the regulations in Canada, then that privilege of driving, the driver's license, can be taken away. So that is a privilege and how it works in Canada. A right is something that is inherent, it's ingrained. In the US and Canada, it's interpreted differently what a right is. Canada, how we use it in the Constitution is different from how we use it colloquially versus how we use it in legislation, and so it can get very confusing, and I recognize that rights are a very convoluted topic. And that's part of what makes it so interesting too. Anyways, a right is something that you cannot be legally denied. So you have this ultimate right to whatever it may be, in this case, unreasonable search and seizure. And in other cases, it might be freedom of speech, freedom of assembly. We've all heard these terms before. They are kind of buzzwords that we're aware of. And then how they're actually enacted is sometimes less known than we would like. And now you might be wondering, why am I going on about this? Why are rights part of this discourse right now? Why am I talking about that? And really, it's because it leads up to what I'm going to be talking about. That's because the Fourth Amendment grants rights. So the U.S. Constitution, it provides rights. The Bill of Rights gives U.S. citizens these rights to different things. And in this case, the Fourth Amendment, the right to be free from unreasonable search and seizure. That means that it cannot be legally denied. Now, what that looks like in practice can be very different, because we have this stop, question, frisk that sometimes dances the line between constitutional and unconstitutional. And so that can get really blurry really quickly, because at what point does it become unreasonable, and at what point is that right then being legally denied to the citizen? And so that's kind of the basis of this topic and kind of the core of it. And I'll just be talking about the law of this. This is not a political discussion. This is more of a legal-based topic that I think is really important. And especially as we get to 2025, it's really important that the citizens are aware of what's going to happen. They're aware of the consequences, and we can act based on that knowledge. Informed decisions are really, really important. This topic came up because I recently heard this potential policy that Trump is wanting to enact in the US once he begins his administration, in that he wants to reassert or strengthen stop and frisk practices. If you're not already aware, stop and frisk practices are essentially, in Canada, we call it carding. And it's when people are walking down the street, minding their own business, and the police stop them and ask to see ID. And it's kind of this fishing expedition where the police are just trying to get something to potentially find drugs, weapons, etc. And so this stop-question-frisk in the US is kind of a build off of that, where it's stopping a person on the street, minding their own business, questioning them on their identity, on what they're doing, where they're going, all these things, and then finding any basis to then frisk the person. And now I'm sure you can understand why this could be highly problematic, because most people, I don't think, want to be frisked randomly as they're going to get groceries. And that's a huge violation of privacy, and ultimately is unconstitutional as a violation of the Fourth Amendment right. So why then would Trump want to enact this policy? So I looked more into this topic and tried to find, is this policy actually for real? Is Trump actually talking about this? It seems like a possibility that Trump will try to strengthen stop and frisk practices in the US, though, upon his administration. Liberal-leaning media like CBS News, MSNBC, and The Atlantic had expressed some concern that Trump had brought up this policy and tried to make that part of his platform. Even Forbes, kind of a more politically centered news forum, they brought up the issue as well, and so I found some articles on them. What I found really concerning, though, is that I found a lot of the conservative media forums weren't talking about it. In fact, I only found one article talking about stop and frisk policies, and it was from 2018. And that was when Trump was originally talking about trying to strengthen the stop and frisk policies. So this is not a new idea. This isn't a new concept. Trump has already proposed to do this. And so I don't think it's an unrealistic possibility that in January we will see these changes come to light. And really, the fear that is put into conservative media does make it highly likely that people will want to believe that this is a good idea. One of the fear tactics in that one article I found was that they were trying to assert that stop and frisk practices actually save lives in the long run. The argument is if police can stop people, find drugs and guns on them, it'll reduce crime in the area. But what we see happen is that minority groups are often targeted by police. And so that creates a racism-based policing where carding is used to essentially harm minority groups. And again, like I talked about, nobody wants to be stopped and frisked, but traditionally in the US, minorities are at a much higher risk and live in a much greater fear of being stopped and frisked by the police. And so we see this, the statistics show it. It's not unknown that this occurs. But what I found in this article was it didn't deny that this was occurring and that minorities were most often targeted by the police, but rather the article mentioned it and noted that it's actually Black lives that are the most saved, that the numbers are saved by stop and frisk. So it's essentially this, well, the good outweighs the harm. The harm to the minorities by frisking them is worth it in the long run because it saves lives. Now, the problem with this argument is really at its base, it's unconstitutional. As I discussed at the beginning, a right is something that cannot be taken away, and it has to be enforced. You're legally entitled to this right, which includes the right to be free from unreasonable search and seizure. And so stopping and frisking without a basis to do so is really unconstitutional, and that's a real problem. Now, we could argue that, well, if the police have a basis for it, if someone's acting suspicious or they look suspicious or they're doing something and the police pick up on it, that the police should exercise their discretion. And absolutely, I agree with this. The police need to do their job. They need to be able to exercise discretion, and what they do is really, really important and dangerous. So I'm not at all saying that police should be deprived of that discretion. However, practices like stop-question-frisk have not been found to actually increase safety and have actually been found to create hazards for minorities. And that is highly problematic and highly unconstitutional. And so this is why this is outside of politics. This is outside of kind of that discourse and controversy, because it's a legal issue at its core. I think all of us can agree that we want rights, and when we have rights, we want them to be protected. And the Constitution in the US is supposed to be kind of that focal point of rights. It's supposed to be the essence of US rights. And if we cannot protect those, then what rights can we protect? And so I really, really want to be a proponent for supporting the rights to be safe from unreasonable search and seizure. And that's for everyone in the US, not just for a certain group. That is for every single person. And so if we impose these stop-question-frisk policies for the police to follow, we already know that they'll target minorities. We will not be surprised when minority arrests go up. This will occur because we've already seen it happen, and we've tried to go back against that. We've tried to reduce that, and Trump is threatening to bring this policy and essentially regress us back 20 or so years into what used to be really hazardous with stop-question-frisk. So this is a really, really deep issue that's ingrained in our history, but it doesn't have to be repeated. So let's talk search and seizure in the US, and then we'll talk about Canada a little bit. So under the Fourth Amendment, search and seizure generally requires a warrant, which has its own requirements of being signed off by a magistrate and having probable cause beneath it. However, in some cases, the Fourth Amendment does permit a warrantless search and seizure. And if you recall, the language of the Constitution is unreasonable search and seizure. So some warrantless searches can still be seen by courts to be reasonable. There is a legal test for all of these, and so I'll kind of give you the basics of it. So warrantless search and seizure can be done to seize property, but only if it is in plain view. And so that often occurs when someone's being arrested. Perhaps there's a warrant to go in their house, and they're being arrested in their house, and out on the table is a firearm or drugs or whatever have you. And the police can then search and seize that property because it's in plain view, because they can see it, it's not hidden, it's not invading privacy to take that property, because that is the essence of the Fourth Amendment, is to protect personal privacy and these reasonable expectations of privacy. Furthermore, other than seizing property without a warrant, police can also seize a person or arrest a person based on probable cause if they're in public, or with a warrant if it's in the home. So we maintain this warrant requirement if an arrest is occurring in the home because there is a greater expectation of privacy in one's home. However, if the police have probable cause to believe that you committed, are committing, or will commit a felony, then they can arrest in public, and that's without a warrant. Other special circumstances exist that the police can search and seize without a warrant. That includes exigent circumstances. So what you often see in TV shows, oh, I heard a scream. That would often constitute an exigent circumstance that requires the police to act quickly to either prevent harm or to save evidence from being destroyed. A vehicle search can be done if there is probable cause that the police will find evidence of the crime that they arrested the person for. So there's this really popular case where someone gets pulled over for, I believe it was speeding, and then the police search and frisk this man and find drugs in his pocket. You cannot find evidence of speeding in someone's pocket, and that was really the essence of the court opinion in that case. There's also hot pursuit. So obviously if a police officer sees someone committing a crime and they're in pursuit of the person, they can search and seize when they catch up to them, even without a warrant. There's also an inventory search, which is when a vehicle is seized, the police can search and inventory the vehicle. So it's for the purposes of keeping people's items safe so that the police can't be sued later for that person missing property. And it's really interesting because Canada actually expressly does not have inventory searches. And that has kind of evolved over time to where the courts have recognized that inventory searches were often leading to violation of constitutional rights. And so we do not have inventory searches in Canada, but the US still does have these inventory searches without a warrant. Finally, there is a search incident to lawful arrest. So when a person is arrested, they can be searched to protect the officer from harm. So if the person has a weapon on them, and also to preserve any evidence that might be on that person. So those are the special circumstances that can allow police to search and seize without a warrant and still remain within the boundaries of the Fourth Amendment. And so those all make sense. But where the blurry ground begins is with stop-question-frisk, because constitutionally, if there is probable cause, they can be arrested and then searched on that lawful arrest. But what makes an arrest unlawful? What makes it unreasonable? And that is the core of this issue. And essentially what Trump is proposing is to reduce the standard of what probable cause needs to give rise to these arrests and make it much easier for a police officer to justify the arrests that they're conducting. And so that is one of the dangers of Trump's policies if he strengthens the stop-question-frisk practice in police forces in states and federally and just across the board there. And so it's really disheartening because the U.S. has come a long way. And I made reference to that earlier, how we don't need to repeat history. And it's really true. So in the U.S., it used to be that this was already an issue. We talked about stop-question-frisk. It was an issue. We acknowledged it, but we wanted to deal with it. And how that came about was in a case called Terry, was a seminal case for U.S. law regarding stop-and-frisk practices, because it established what it takes for a police officer to be able to stop someone and to frisk that person. And this was a really, really big deal because at the time it was a really big problem that minorities were being targeted by these police practices. And so Terry was this huge change to the legal environment and also really inspiring for upholding the Fourth Amendment. Because that's really what this comes down to. It's all about the right to be free from unreasonable search and seizure. And if we don't have that Fourth Amendment right, and if it's not protected, then it's a kind of scary world. And what rights will be upheld at that point? What part of the Constitution will be maintained? At what point is there no longer a Constitution? So Terry, in the stop-and-frisk discourse by the court, they established that it requires reasonable suspicion by the police officer to stop a person on the street. So carding practices in Canada, just stopping people in the road, just asking them their identity, want to see ID, asking them where they're going. This now requires reasonable suspicion. Obviously, that is open to interpretation because what is reasonable? What is suspicion? At what point does a hunch become suspicion and then evolve to probable cause? And this is kind of really ambiguous and amorphous, and you could see how courts could potentially interpret this differently. And they do. Across the states, they do interpret this differently already. So Terry established the reasonable suspicion, and then it also went further to say that there has to be reasonable suspicion to stop the person. So there's suspicion that they committed, will commit a crime, that they have evidence of a crime, something to that effect. But then there has to be the second step of the police officer also has to have reasonable suspicion that the suspect is armed to be able to frisk them. So no longer can they just arbitrarily frisk people based on a hunch that they could have drugs on them, but now it has to be this reasonable suspicion of being armed, because this is really focusing on the safety aspect, because safety is the only thing that can really, or should really, from a legal perspective, overcome the Fourth Amendment. This is a legal right to be free from unreasonable search and seizure, and that shouldn't be given away lightly. But group safety, individual safety, officer safety, those do sometimes give rise to kind of hedging on the Fourth Amendment a little bit. So that is a two-step Terry test that is reasonable suspicion to stop the person and then reasonable suspicion that the person is armed to be able to frisk them. That is the law as it currently stands. Open to interpretation, but that's kind of the core of it, the essence of it, and what courts are following right now. So that is a constitutional case because it's interpreting the Fourth Amendment. The Supreme Court has the final say on the U.S. Constitution, and they've determined that this is what the U.S. Constitution requires, making it a constitutional law. Terry stop and frisk rules are constitutional and protected by the Constitution. So what happens then if that is altered and the standard is lowered so that stopping and frisking becomes more regular police practice in a way that overcomes the Fourth Amendment? That is the question that we're wrestling with tonight and what I really want to bring to your attention. This isn't some high-level topic that doesn't affect you or me. This does affect you and me because we walk down the street, we pass police officers, and I, for one, don't want to be stopped randomly by a police officer who has no right to do so and have my day interrupted and my bodily autonomy invaded. I don't want that. And so for me, protecting the Fourth Amendment and protecting this right to be free from unreasonable search and seizure is really, really important. And I really want to stress it should be important to you too, because you, if you're an American citizen, you have the ability to change legislation. You have the ability to vote. You can impact how these policies evolve over time. And I think this should be something that should be on the forefront of your mind. Stop-question-frisk is impacting everyone. And so the idea that Trump could impose these policies following January 20th, then it does impact you. And it could have a huge impact on the constitutional landscape of the U.S. So I'm going to get into that now. So why does this matter? This matters across political spectrums because it will change how the Constitution is followed in the U.S. And that is arguably going to change the future history of the U.S. Let me explain that a little bit. I'll try to break it down. So the Constitution, obviously the supreme law of the land. But who kind of interprets that? The Supreme Court. And so if Trump imposes these policies for stop-question-frisk, allowing it, making it more permissible for police agencies to engage in this activity, it's likely that courts could find, may find, should find that these practices are unconstitutional. For the many reasons that I just talked about and many, many more, it impacts the Fourth Amendment. And so courts should find that it's unconstitutional to infringe on this constitutional right. However, that case could potentially proceed through the levels of court and reach the Supreme Court. And we should say, oh, well, that's fine because Terry was decided by the Supreme Court, so they're going to hold the same again. No. Unfortunately, I hate to be the bearer of bad news, but this is really, really unlikely. And that is due to the fact that the current makeup of the court does not support upholding previous decisions. As I'm sure you're aware, there have been a lot of big cases overturned by the current Supreme Court. We see cases like Dobbs and Loper Enterprises that overcame huge cases like Roe v. Wade and Chevron. So these cases have been overturned by the current makeup of the Supreme Court, and it's not likely to change. If a case got to the Supreme Court that was based on the Fourth Amendment, it's likely we'd see the same pattern of behavior that we've already seen. That is that the Supreme Court is revoking or really changing the rights that U.S. citizens have. Because it might not seem relevant to you. Roe v. Wade might not be relevant to you, or it might not seem relevant. But the reality is that Roe v. Wade and Dobbs overturning it was a decision by the Supreme Court deciding a constitutional issue that weakened constitutional rights. It weakened fundamental rights. But really, this does have an impact on the landscape of the U.S. Constitution, because if Trump imposes policies for stop and frisk, and they get to the next level of court, and they get all the way up to the Supreme Court of Canada, we are likely going to see the Supreme Court rule not in favor of our rights. Rather, the Supreme Court is going to rule that the Fourth Amendment can be overcome by simple reasonable suspicion to just frisk anyone, or whatever Trump proposes in his policy, and that will become the new constitutional landscape. And that may be inalterable. We might not be able to recover from that, and that is the slow degradation of the U.S. Constitution. This is a big deal. If we cannot save this Fourth Amendment protection, even if it seems irrelevant to you, it's going to impact you at some point or another, because we're seeing this erosion of the U.S. Constitution. And so for that reason, it is really important. So Let me share with you Canada's perspective. And by no means am I saying that Canada is perfect. Canada has it all figured out. But I think Canada can be a useful framework to kind of gauge where the US is going and the trajectory of the law. So in Canada, we have the Charter of Rights and Freedoms, and we have a very similar right in Canada as the US Fourth Amendment, and that is in sections 8 and 9 of the Canadian Charter, which is part of our Constitution. And that is the right to be free from unreasonable search and seizure, as well as arbitrary confinement, arrest, essentially. And so we have these two standards of reasonable and arbitrary, and there are tests for that kind of boil down to very similar aspects, but very, very like the US. We've got that reasonable standard. So in Canada, we don't have Terry. That's not our case that we use. Under the Charter sections 8 and 9, a person can be detained on reasonable suspicion. This sounds like Terry. We've got that reasonable suspicion language, and that is similar in Canada. However, how we differ is that a pat down or a frisk, there have to be reasonable grounds related to safety. So this is different from reasonable suspicion. Suspicion is very close to a hunch. When you bring in reasonable grounds, it's almost as probable cause. And these are all just kind of fluffy words, but they do make a difference. This isn't semantic debate. Reasonable grounds means that you have something to base your belief in. It's not a feeling, it's not a vibe, it's not just how someone looks or talks. It's grounds related to safety. And so those can be, oh, I saw a gun in his waistband, he had a knife in his hand, these kinds of things that create grounds for that frisk. And that really ensures accountability and requires police officers to be able to justify why they stopped and frisked someone. And this just adds an extra layer of protection that really promotes people's rights, because we are supposed to be protecting those section 8 and 9 rights of the Charter. Those are constitutional rights. And if we erode them, then we, the people, won't have rights anymore. And so, again, really important. And I think Canada, the reasonable grounds overlay is really important. Now, what is terrifying is that the US trajectory of law has an impact on Canadian law. We've seen it already. We've seen the court decisions in Canada kind of veer a certain way based on American choices. And so if Trump policies come into play for stop-question-frisk, it is very likely that Canada would follow suit. And this might be just the first step of, instead of reasonable grounds, it would be reasonable suspicion to frisk. But that in itself would really reduce the rights of the people. And so this downward trajectory, if you will, or the weakening of rights could really vastly impact not only US citizens, but also Canadian citizens. That is a huge impact in the world. I don't want to live in a world where rights aren't respected. It's called a right for a reason. It is a legal entitlement to something. And I want to be legally entitled to not be stopped, not be frisked by the police. That is the Fourth Amendment in a nutshell. That is stop-question-frisk. It might happen, it might not, but these are the realities that we might be facing in 2025. Trump's administration might impose these changes, and this might end up being another Chevron and Roe v. Wade case where rights are essentially revoked. And it's really, what can we expect from January 2025? What are the legal ramifications, and why should we care? I'm Attractive Nuisance, and thanks for joining me on today's excursion through the Fourth Amendment. Don't forget to subscribe and follow me as 2025 unfolds and history is made. Stay informed and stay empowered. Everyone's rights are your rights.